is the case entitled In Re Investigation Pursuant to 30 VSA 30 and 209 regarding the alleged failure of Vermont Gas Systems, Inc. In Re Notice of Probable Violations of Vermont Gas Systems, Inc. Docket number 23 AP 244. Representing the appellant, Rachel Smolker et al. Is attorney Sarah Starr. Present with attorney Starr is attorney James Dumont. Representing the appellee, Vermont Gas Systems, is attorney Owen McLean. Representing the appellee, Vermont Department of Public Service, is attorney Eric Guzman.
Okay, thank you. Counsel for appellees, have you agreed on splitting up your time?
Good morning. Yes, we have. I'll do the first 10 minutes, and then the Department of Public Service will take the last 5 minutes of appellee's time.
Okay, and you understand it's up to you to preserve time for your co-counsel there. So keep an eye out on the clock.
Yes, thank you, Mr. Chief Justice.
All right, thank you.
We're getting an echo, Chief. I don't know where that came from.
Is it my echo or is it Attorney McLean?
Seems like it's gone now, Chief.
It's gone. It seems to be gone now.
Is it better now?
Into the ether. Yeah. Okay. All right. We'll turn to counsel for the appellant. Please introduce yourself and identify your client and then proceed.
Good morning, Your Honors. I'm Sarah Starr, and I represent the appellants, interveners Rachel Smolker et al.
Thank you.
The Public Utility Commission erred in granting an amended certificate of public good for Vermont Gas's pipeline when no application for an amendment was even filed pursuant to 30 VSA Section 248. The new permit green-lighted without notice to the public an unapproved installation of a natural gas pipeline in what the commission agreed was an irreplaceable and rare Vermont wetland. The Public Utility Commission is a body of limited statutory jurisdiction, and there was no statutory authority to reward Vermont Gas with a new permit as a penalty for violating the existing permit in 6 substantial ways.
But there was a fine, Ms. Starr. There was it wasn't just purely giving them a green light to do it. There was a $150,000 penalty for as built.
The penalty was issued as is permitted by Section 30. There was no authorization in Section 30 for issuing a new permit, which the language of Section 248 says that a certificate of public good can only be issued pursuant to this section. And so it was outside the jurisdiction of the commission to, in addition to giving an appropriate financial penalty, to then rewarding the Vermont Gas with a new permit when it had not even asked for one.
Was there a new permit or was there an amended permit issued?
So it's not clear because the amendment or new permit is embodied in compliance filings. The rule allows for an amendment. The statute itself only contemplates one way of issuing a certificate of public good, and that is under Section 248. And this court's precedent indicates that it is done in a new proceeding. So, however, appellants are not hyper-focused on whether it is a new permit or an amended permit. The focus of the appellants and the concern of the appellants, and what should be of a concern to the public if the public had notice of this, is that the procedure outlined in 248 is followed.
Well, let me, if I might interrupt you there. The briefing, your briefing makes the point that the, as you call it, ultra vires procedure prejudiced the public. So could you be specific about how it prejudiced the public?
So a certificate of public good is following the procedure. It's not only a statutory requirement. Following the procedure gives landowners and interested persons and the public notice of a project that is going to affect their environment and their lives. Following the procedure is essential to maintaining the public trust in the process enacted by our legislature to protect Vermonters and the environment. And so the Public Utility Commission cannot jettison the permitting process and still state that the pipeline remains in the public good.
But doesn't the department have a role in protecting the public? I mean, you have two different, you have the department representing the public and you have interveners who have a specific interest. Is there a distinction between the two?
Yes, the interveners are the public, and the department, is an agency of the state. And so there is a difference between the state and the public.
But its job is to protect the public, is to represent the public in these types of proceedings and rate proceedings or in any other type of Public Utility Commission cases. That's its role.
That is true. However, my experience as a public defender indicates to me that state agencies are not always looking out for individuals.
Counsel,
and sometimes individuals need their own representation against the interests of the state.
Counsel, may I interrupt you? Have you finished that answer? I didn't mean to cut you off.
Oh, no, I'm finished. Thank you.
All right. Leaving aside the public interest in light of our decision in Baird, let me confine this question to your clients alone. From the time the PUC investigation began until the decision to order an amended CPG, did the PUC ever specifically tell your clients that an amended CPG could be the result of the investigation?
Never.
But they did indicate that there would be potentially remedial action, right?
Yes, remedial action. And remedial action is absolutely contemplated in Section 30, which was the statute under which this investigation was conducted. Remedial action means that Vermont Gas is going to remediate the pipeline to bring it into compliance with the CPG. That didn't happen. There were remedial measures taken to try to make the pipeline as safe as it could be after the fact without eyes on it once it was already in the ground in the swamp. But remedial action does not contemplate remediating the permit. That is a modification, not a remediation. And so a modification of a final order needs to be done in a new proceeding pursuant to this court's precedent. And again, it's not significant whether the new proceeding has a new docket number, but it does need to be amended in a new proceeding.
The entire issue for every issue from the beginning, that everything would be relitigated, or just the non-compliance?
So Vermont Gas needs to make an application, and certainly the findings and the evidence and will inform what Vermont Gas puts in its application and what the commission and the public, need to consider. But I don't think it's appropriate or necessary for this court to say what needs to go into that application.
If we disagree with you on the issue of whether it needs to be a new proceeding, is that fatal to your claim here? Or does the lack of
No.
notice still pertain to the existing docket number?
Whether it's a new proceeding or in the same docket number does not matter. It's not fatal to the argument. Then there needs to be notice and there needs to be an application. Without an application, I mean, the example of the licensure is a very good example of how the lack of an application confuses this process. If Vermont Gas is required to file a new application, I'm pretty sure that they're going to get a licensed engineer this time to sign off on it. As it stands now with no application, there's no incentive to do that. So a new application has to be made for an amendment, and notice needs to be given to the public, and the process in Section 248 needs to be followed. And if there's no other questions, I'll reserve the rest of my time.
Okay, thank you very much. We'll turn to counsel for the appellee. First counsel to the appellee, please introduce yourself, identify your client, and then proceed.
Good morning, Mr. Chief Justice, and may it please the court. My name is Owen McLean from Sheehy, Furlong, and Beam, and we represent VGS in this appeal.
Thank you.
The Public Utility Commission issued a certificate of public good for the construction of the Addison natural gas pipeline more than 10 years ago in 2012. In this case, the commission conducted an investigation into nearly every aspect of the project's construction. And while the case below was complex and extensive and lasted 6 years, the scope of this appeal is very narrow and very straightforward. There is simply no statute, rule, or case that supports interveners' claim that an entirely new CPG process needs to be recommenced here.
What about an amendment?
The commission wants to amend the CPG in this case, Justice Cohen, for two basic reasons. First, to document the construction of the project as built based on the evidence that it has gathered in this case. And second, to formally adopt and memorialize additional operating conditions that VGS has agreed to during this proceeding and has implemented since they were recommended by the experts during the course of this case. And those are designed to ensure that the pipeline does remain in the public good. Notably, the commission substantively found, based on the evidence in this case, that not a single change to the construction had any impact under the Section 248 criteria, and that the pipeline would remain in the public good as long as VGS continued to adhere to the conditions that it's already agreed to. Accordingly, the substantive decision of the commission, which is not on appeal here, is merely sort of memorialized in CPG amendments. The narrow question,
But don't the interveners have a right to be part of a process that makes a determination on whether or not the amendment is as portrayed?
Yes, absolutely. The interveners in this case were parties to the initial CPG proceeding, some of them, and have participated robustly in this 6-year investigation. They have hired experts. They have submitted testimony about whether or not these changes are substantial changes under Rule 5408, which is the only rule that governs whether and when to amend a CPG under Section 248. And they have participated robustly in the process the commission has contemplated here for amending the CPG. Namely, following the final order issued, they asked VGS to submit a compliance filing. That compliance filing, as I mentioned, memorialized the CPG amendments and identified the additional CPG conditions that were recommended by the experts in this case. And the commission has provided the parties an opportunity to comment on that compliance filing. The commission has not yet issued a CPG amendment, notably. And so the characterization of the final order in this case as if it issued a new CPG is a mischaracterization of the proceeding below. The commission has issued a final order regarding this investigation and detailed a compliance mechanism under which it would consider CPG amendments, which are still under consideration below. That kind of post-CPG procedural process is standard administrative procedure for the commission in post-CPG proceedings. And this court has recognized that process in two separate cases. In the In re UPC Win case, the court said the commission, quote, acted within its discretion in using post-certification proceedings to evaluate compliance with CPG conditions. The court also found interveners' opportunity to comment on post-CPG conditions in that case was sufficient process, and that the commission was not precluded there from holding, quote, additional hearings if it should find them necessary. And notably, if the commission had a reason to conduct additional proceedings here, it would. And there is simply no presentation of a basis for a need for additional hearings. And
I thought it made it fairly clear that there's no need for additional hearings based on the circumstances here. That's actually the specific finding. That's not required. Even though they made a finding that there was a substantial modification.
The commission, if I take your question correctly, Justice Cohen, the commission in this case has decided that no further proceedings are necessary, and it's done that twice. First, it did it in its final order when it determined that the recommendation of the hearing officer to conduct a separate case was unnecessary based on the extensive evidentiary record in this case. And then it did so again when it denied interveners' motion for reconsideration and rejected their argument that there was a need for additional hearings. So I think the commission has twice now decided that there is no need for an additional hearing. And notably, even on appeal, appellants have not identified what we would achieve in a new proceeding, absent restarting the Section 248 process, which, as I mentioned, was already achieved over 10 years ago. And there's no basis under Section 248, no basis, no law, no language whatsoever that supports the notion that one has to restart that process in order for the commission to amend a CPG under Rule 5408.
Mr. McLean, is there any authorization under 248 that if there is a substantial change to the CPG, that the board can penalize the utility without having additional hearings and address it in the penalties and address it as a penalty?
The commission has, as this court has recognized, broad discretion under Section 248 to make a variety of determinations that are both factual and public policy-based decisions. The commission has exercised its rulemaking power to promulgate a rule that governs when a CPG should be amended under Rule 5408. And it has the authority to do that. And the legislature has already acknowledged in Section 248 itself the existence of the rule, and the commission's practice and procedures under Rule 5408 are therefore essentially codified in 248. And the commission's authority to approve an amendment in a post-CPG proceeding is sort of patent on a basic administrative procedure that this court has acknowledged in two separate cases. Again, it is standard practice for the commission to, following the issuance of a CPG, conduct an investigation into any deviation from that CPG, evaluate and impose remedial action as necessary to either penalize a CPG holder for violations of a CPG or to ensure that appropriate remedial action is taken. And I'd like to note, with respect to Justice Eaton's question earlier about whether these particular interveners were given notice that a CPG amendment could be obtained in this case, and the answer was no. The question, the answer, I think, ignores the notice that was provided to everyone in this case when it was commenced. And this is an order from back in 2017, where the commission stated, this investigation will be conducted by the commission and will determine whether VGS's deviation from the project plan is a material or a substantial change to the project plan. And if so, whether it is appropriate to order any remedial action, impose a penalty, or take any other steps authorized by law. And I'd just like to note that a substantial change only means one thing in this context. It means whether or not an amendment is required under under Rule 5408. That's the only relevance that a substantial change has. That's the entire basis of the 6-year proceeding below, was to determine whether these were in fact changes under Rule 5408. That was the entire purpose of this investigation. Sorry.
They did make a finding that there was substantial change. And then, but they had enough information from the years of litigation that have gone on in this case that to not have to reopen it. But the specific finding that there was a modification, substantial modification, was clearly made by the board in making its determination.
Absolutely, Justice Cohen. The commission found that there were 5 individual violations of the CPG, precisely because there were 5 changes that constituted, quote, substantial changes under Rule 5408. In each case, the commission has already found that not a single one of them had a undue adverse impact, or any actual harm under the Section 248 criteria. That finding and conclusion is not challenged in this case on appeal. The interveners have identified no need for a new proceeding and no basis to throw away a 6-year investigation that has provided adequate evidence for them to make the substantive finding they need to make.
Well, let me interrupt. You have identified no need. Isn't there some issue between you about the construction plans and the licensing of the engineer that you used? I don't really understand it all, so perhaps you have enough from that you could comment on it.
Yes, thank you, Mr. Chief Justice. And then after I answer, I'll defer the rest of my time
All right.
to the department.
Sure. Yeah.
There were many issues between the parties in this case, and the interveners raised many challenges alleging environmental harm of all kinds and harm to the public safety. And that was precisely the purpose of hiring a third-party pipeline engineer who conducted a thorough investigation of nearly
This was a gentleman from Texas?
Yes, Mr. Chief Justice. He's an internationally renowned pipeline expert that was hired by the commission to conduct a thorough investigation of every claim that the interveners lodged in this case. And in every case, the commission found, either based on his investigation or based on other expert testimony provided by the parties, that there was not a single serious issue to be raised. So while there were violations of the CPG, there were no impacts on either the environment or public safety. And if I may, I defer the rest of my time. Thank you very much.
Thank you very much. We'll turn to second counsel for appellees. Please identify your client, introduce yourself, and then proceed.
Thank you. Good morning, Mr. Chief Justice, and may it please the court. My name is Eric Guzman. I represent the appellee, Vermont Department of Public Service. I would like to just briefly address 2 points in support of a decision by this court to affirm the commission's order below. First being that the commission's decision to conduct a CPG amendment procedure as a post-compliance process appropriately addresses the procedural needs of this case, considering the substantial evidentiary record and the commission's findings that the ANGP, as constructed, presented no undue adverse impact to the relevant Section 248B criteria. And second, in addition to that contested case procedure below, the prescribed ongoing compliance case process granted the appellants, as well as the other parties in this proceeding, an opportunity to provide comments on and propose CPG amendment conditions and request additional process, which further demonstrates fairness of this proceeding as a whole.
Mr. Guzman, I'm sorry
Yes,
to interrupt you, but so the fact that the commission did find there was a substantial change to the CPG, it doesn't matter if consequently they find that there was no adverse impact. Is that what you're arguing? That's why the interveners don't need another hearing. That's why the PUC could just go ahead and proceed.
If I'm understanding your question correctly, Your Honor,
Mhm.
I would not say that a finding that actual impact is not is irrelevant in this proceeding. I think it is the this entire proceeding was noticed as an investigation which included the entire construction, performance, and safety of the pipeline, and the potential and actual impacts were thoroughly evaluated. First, identifying those potential impacts to the Section 248
You've
criteria.
got 1 minute, counsel.
Thank you, Your Honor. First being the potential impact to this Section 248 criteria, and then the parties as well as the Commission's independent experts conclusions that there was no actual impact to those Section 248B criteria. The findings of potential and actual impact were thoroughly based in the evidentiary record and thoroughly briefed by the parties. The department, VGS, Velco, and the interveners both did and had an opportunity to address the findings of actual impact within the evidentiary record within briefing. And in those remedial measures that were recommended by both the independent investigator and the department were subject to the contested case process, were subject to rebuttal, additional cross-examination, and briefing by the parties. So the remedial measures that—
interrupt you there. I apologize again.
Yes, Your Honor.
So my understanding that after you've gone through that litany of procedures, that the interveners had adequate due process. They were involved, they went through all these other proceedings, therefore that's why it was not necessary to notice another hearing. Is that your argument?
Yes, Your Honor.
Counsel, your time has expired. Just please answer the question and then
Thank you, Mr. Chief Justice.
conclude. Yeah.
Yes, Your Honor. An additional hearing, as found by the commission, it was not necessary based on that evidentiary record. However, the final order does address in the compliance process the opportunity for submission of additional comments, and the commission notably states that further process may be obtained.
All right.
So,
Thank you very
thank
much.
you.
As I say, your time has expired. How much time does the appellant have, please?
Appellant has 5 minutes and 46 seconds remaining.
Counsel?
If Vermont Gas is correct that no new CPG has issued, then this pipeline is operating without a permit right now. Because under this court's precedent, the CPG that was issued in 2013 remains in effect for the project as approved. There was a substantial change, not a substantial change, multiple substantial changes, including burying a natural gas pipeline. The bottom line is that there's a gas pipeline floating in a swamp, and that is a major concern to the appellants. And if the public had noticed, and the towns and the municipalities had noticed, in 2023, and this evidence was taken in 2020, but if proper notice had been given to the necessary parties in 2023, we cannot predict what the new information would be or the new concerns raised. If this project that was approved in 2013 were brought in 2023, it probably wouldn't be approved through a wetland, given the flooding and erosion that we know is happening in Vermont. So what the department and Vermont Gas are asking is that this project that they decided to build without authorization be treated as a fait accompli, which is exactly what the legislature was concerned about back in 1969 or in the 60s, I forget the exact year, when it talked about the necessity of the public process when we're making decisions for major infrastructure that affects our natural environment.
Isn't that the role of the Public Service Board? I mean, the Department of Service, that its entities be responsible
Justice
for-
Cohen, we're getting a lot of echoing. I don't know if anybody else is, but I am.
I'll just withdraw the question, Chief. Go ahead.
Well, no, I'm not trying to get you to withdraw the question.
I'm not sure.
We can't understand you. That's the problem.
Well, when can you? I mean, it's like, you know.
Chief Justice, perhaps if folks who aren't talking can mute their microphone, then we might not get that.
That's a good point. Yeah.
Or I can put the video off.
While he's getting his audio straightened out, can I ask a question, Ms. Starr?
Well, I muted myself, so please go ahead. I'm gonna.
Okay, so Ms. Starr, can you hear me?
Yeah, yes.
Okay, if let's assume we agree with you, what is it that you would like the mandate here to be? Is it remand for a new hearing from square one, remand for a new application, but you can use evidence that's already been done, that's already been considered? What are you asking for?
A remand with instructions for VGS to submit a new application.
And does that mean that with the new application, everything has to go back and be redone?
I don't think it means that. I think that there's extensive evidence in this case, and it can certainly be relied upon by the commission. But other things were not clear. For example, the commission even found that it wasn't clear whether a licensed engineer needed to sign off on a particular portion of the project, and so additional evidence might be taken on that. Following notice to the appropriate persons and entities, new issues may arise. The parties can certainly ask the commission again to take judicial notice, as it did in this case, of the prior docket of what had occurred here. And so, no, I don't think in the interest of judicial economy that it would need to start from scratch. And I don't think that the commission would stand for that. But that the fact of not wanting to start from scratch doesn't jettison the need for a hearing at all.
Thank you for letting me jump in, Justice Cohen.
Oh, no problem.
We still.
Am I still echoing? Am I?
Yes.
I am. Okay. Thank you.
You put the question in the chat.
I'll do that to you.
So the substantial change doctrine, that the cases that Vermont Gas was talking about the ongoing jurisdiction for post-certification proceedings, those are not substantial change cases. This court's precedent establishes a bright line that when there's a substantial change, the permit remains intact for the existing project, and an amendment must be applied for and obtained for the modification. And so the ongoing ability to monitor and do post-certification proceedings doesn't get rid of the substantial change doctrine, nor does the broad authority in section 209. It doesn't render the requirements of 248 a surplusage.
Your time has expired. Can you wrap it up, please?
I'm finished. Thank you.
All right.